Hi everybody, welcome to this year's Shaking Foundations at Stanford Law School. My name is Joseph Trujillo, and I, along with Rob Quirk, are one of the co-presidents of Youth and Education Advocates here at the law school. And we'd like to thank you for joining us for our panel on different perspectives on education reform. Each of our 5 distinguished panelists will present their work and experiences in improving how we educate our youth, particularly in California. I will introduce each in the order of their presentations. Marcellus McRae is partner at the Los Angeles office of Gibson, Dunn & Crutcher. He'll present his work on Vergara versus California, which challenges the constitutionality of various education code provisions pertaining to teacher dismissal and seniority-based layoffs. Following him will be Mr. Seth Eckstein, who is an employment and labor attorney for Oakland Unified School District. He will explain how the dismissal and suspension process for certificated employees, including teachers, currently operates at Oakland Unified. Following will be Ms. Lori Run, who is the legal director of the California Teachers Association. She will respond to the merits of the Vergara case and address the CTA's position on what it believes is needed for education reform. Josh McIntyre as counsel at Rocket Ship Education, a network of 9 pre-K through 5 public charter schools with over 5,000 students in both California and Wisconsin. He will discuss the staffing and financing issues covered by the other panelists as they apply to schools here in California. And finally, Mr. John Fell is the managing attorney at the Public Advocates in San Francisco, where he focuses on educational equity issues through litigation, policy advocacy, and partnership with grassroots organizations. He will present his work on the campaign for quality education versus California, which challenges the constitutionality of California's school finance system and demands the state create a funding system that meets the cost of preparing students for social success. Following John's presentation, we will open the microphone to you, the audience, for questions before concluding our panel at 4 p.m. Please join me in welcoming our first panelist, Mr. McRae.
Thank you. As you heard, can everybody hear me? I've never been accused of being soft-spoken, so I don't think it's going to be a problem. Besides, I've got to manipulate the keyboard at the same time. I'm a partner at Gibson, Dunn & Crutcher. We do represent the Vergara plaintiffs in this case. I'm going to jump right into it to give you sort of a conceptual overview of the case, some of the underpinnings of it, and then getting more specifically into the issues. I'm asked to speak about 10 minutes, so I apologize in advance for moving at a pretty quick clip. But we start out with the concept that California's public education system has actually fallen behind the rest of the nation on many different indices. There are a lot of contributing factors, and I want to make very clear at the outset that our lawsuit does not seek to be a panacea to address all of those problems and to invest all of those contributing factors. Instead, it focuses on a series of obstacles, namely a series of outdated laws that prevent school administrators from making teacher employment decisions that are driven by the needs of the students. And one of the more salient dimensions of that is that these particular statutes that I'm going to talk about really don't allow administrators to factor a teacher's impact on student learning into fundamental decisions with respect to, for example, dismissal to the extent that you can actually pull the trigger on that, which we're going to get into as a rather cost and time prohibitive measure, or in particular in the case of reverse seniority with layoffs. And our basic point here is that every decision that affects public education should be made with the interest of students in mind, first and foremost. We want to start out with the concept that the California Supreme Court, both in 1976 as well as in subsequent cases, recognizes that there is a fundamental right to education. More specifically, we're talking about a constitutional right, and I'm going to keep harping on that because once you do an analysis where you're talking about some of the statutes that we're going to be focusing on, you've got to remember that what we're juxtaposing are not merely, nebulous rights against rights. We're talking about a constitutional right to equality of education against certain statutory rights. In the Serrano case, the court recognized that the purpose of education is to have children compete successfully in the marketplace. And in the Butt case, the court went on to recognize that indeed the obligation of the state and the obligation of the school districts extends beyond just ensuring the funds are distributed equally. Again, there's a stewardship here with respect to young people as far as ensuring that they have the ability to compete effectively, and a hallmark of that is equality of educational opportunity. I want to talk about teacher effectiveness and how it matters. I don't think it's too controversial that obviously the overriding aim of education is student learning. It should be. I don't think, again, that you're going to get violent debate on that. It's also the case, and it should be pretty obvious, that teachers are more effective in some instances than others, and that teachers actually do matter, because if they don't, why do they get paid? Why do they go to schools and get credentials? Why are they standing in front of students? Obviously they matter. Obviously we can calibrate the contributions that teachers make to students, just like we can do that in other fields. And in the area of reform movements in education, there have been a lot of interesting studies that have come out, and I'm going to try to distill these down with the time that I have, that the difference between having a really good teacher or an effective teacher and an ineffective teacher can be exponential. That if you have a good teacher, that you can learn as much as 1 year's worth of curriculum in a year as you should. But if you have an ineffective teacher, you can actually get a half of that, a third of that, and in some cases, you can have an even more adverse effect where someone actually regresses. And so we're talking about people's lives and potential livelihood here in the sense that there are studies that show that if you replace, let's say, the bottom quartile, or bottom 5% rather, of an average teacher, ineffective teacher with an average teacher, you can affect the earnings for that class by as much as $1.4 million a year. There's also studies that show that if you replace that bottom 5%, that you can achieve an elimination of an education gap that we have with other industrialized countries like Finland and Canada. So as far as sort of the long-term effects, as well as some of the immediate effects, teachers matter. Obviously they do. We know that they have an impact. And the idea here is to make sure that that impact, that imprint that students have with respect to learning and achievement is something that school districts are allowed to internalize and put into the calculus of decision making as far as employment decisions. Now the other concept, and I want to make very clear that we're not talking about an orthodoxy here in terms of measuring effectiveness, but you do get pushback from some circles that, well, measuring teacher impact is too complicated. It's esoteric mysticism. How do you compartmentalize the different factors that contribute to student learning? And not to get into an academic debate about this, because as I said, we don't prescribe one way of measuring teacher impact, but there is a good deal of science and study out there that has been peer-reviewed and tested that you can, using value-added methodology and using standardized tests and student gains, have a predictive model that shows, by isolating factors such as people's socioeconomic status, the different levels that they come into school, other externalities, that you can actually determine the impact that a teacher has. Those also can be used, however, in combination with other factors like classroom observations, student perception surveys, etc., as well as I said, those standardized tests as well. Now, the statutes that we're talking about in this particular case fall into the following buckets. One is the permanent employment statute that we're challenging. What's the basic point here? In California, districts have what is touted as 2 years, and it's actually much less. It's the second year of a teacher's probationary status to make a determination by March 15th whether or not that person is going to be given permanent status. When you look at it, actually, the decision tree actually starts in what probably is more like January or February in order to be able to meet that March deadline. So in effect, you're really talking about less than 18 months within which districts are able to make that decision. That's 1 year worth of student data at best, and maybe 1 year of teacher observation. And the basic point that we have is this, is that the majority of states in this country actually don't grant tenure in the first or second year. They actually, the majority of them do it beyond 3 years. And that it's an unduly compressed period of time of 18 months to make in excess of a $2 million investment to determine whether or not you're going to give somebody permanent employment. The dismissal statutes, and what can be charitably described as Byzantine, these statutes are actually very prohibitive in terms of cost, in terms of time, in terms of documentation. I won't bore you with the number of studies and surveys that are out there where school site administrators say they won't even pull the trigger to dismiss someone because, for example, in New York, to use an example out of state, $250,000 on average to dismiss a teacher. We've seen studies, and there were articles in Los Angeles, for example, where to get rid of effectively 7 teachers, it took, on average, $500,000 and 5 years to do it. It's absurd. It just should not take that long. And in fact, there was a recent effort under AB 375, which we criticized because we thought it didn't go far enough, and basically it was a placebo. But the underlying current of that is that obviously the system needs to be streamlined. And in fact, when Governor Brown sent out his veto message on AB 375, he concurred that it needs to be streamlined. It seems like we're all in violent agreement that it needs to be streamlined. It's just a question of how it's going to be streamlined and to make sure that it doesn't butt up against and eviscerate this right to educational opportunity and equality of educational opportunity. The LIFO statute, which is the statute where they do layoffs, I mean, this one is probably one of the clearest examples of what I would call sort of the gap between rational decision-making and information. The statute actually requires that you lay people off on the basis of reverse seniority. So the last person in is the first person out. Notice that I said reverse seniority. In other words, the statute doesn't allow you to make a determination of who should be laid off based on whether or not the person is an effective teacher. You're designing failure. You're ensuring that because you cannot look at, even if they're skipping criteria in some rarefied area of credentials, that someone teaches a particular class, that's not going to be enough to override the fact that in many of these cases you're making decisions completely divorced from whether or not someone has a positive, negative, or neutral impact on students. Those are the statutes that we're talking about. And we're saying that there is an equal protection violation. What's the nature of the equal protection violation? It's really in two camps. One prong of it is this. Because you have what we call quality blind decisions that are made under these statutes that do not allow school districts to take into account someone's effectiveness in terms of whether or not they're going to be laid off, and because they don't have a sufficient amount of time to make a decision on whether or not a teacher is going to be effective in 18 months, and because of capacity constraints in the system, you cannot possibly expect school districts to spend that much money to be able to get rid of all the ineffective teachers that are there. It means that we're placing ineffective teachers in front of students on an ongoing basis. It happens whether it's a wealthy white school, where in one class you have somebody who has an effective teacher, and in the next class they happen to get stuck with that teacher that people know is ineffective, but again, they're not going to pull the trigger to get rid of them, or not get rid of all of them. It also happens, unfortunately, to a disproportionate extent in black and brown communities and low-income communities. I'm going to talk about that in a bit. So the equal protection analysis really is twofold. One is, as I said, it's not necessarily a component of race or socioeconomic status. It is an equal opportunity offender in that sense. And at the same time, you do have a disparate impact prong where black and brown and low-income communities are adversely and disproportionately affected. I've talked to you about the permanent employment statute, but again, mindful of the time, this is just illustrating how when you look at the number of states in the United States, how many of them have tenure beyond 3 years, 4 years, 5 years, 6 years, sometimes even 7 years, and in fact, some states don't even have tenure. They have annual contracts, something that many people outside of the context of education may be familiar with, which is that you're evaluated on an ongoing basis and your security is really contingent in large measure on your productivity, which is, not an alien concept in much of the marketplace. This is a flowchart that shows the dismissal statute, as I said, very complex, more importantly, very time-consuming, very lengthy. And just a couple of points with respect to this. People often look at this and they'll say, well, if you have anything that sort of avoids this very layered process, isn't that going to eviscerate due process? I want to say a few points about that. First of all public employees have something called Skelly rights. And the reason that that's important is because even if these rights that you're looking at under the dismissal statutes didn't exist, here's what you would have as a public employee. You would have a right to have a copy of the charges and materials on which the action is based, and a right to respond, orally or in writing, to the proposed termination. Do you know what that is? You can equate that with due process. What is not due process, in terms of what is not constitutionally mandated, is having a full-blown evidentiary hearing in front of a 3-judge panel. There's no constitutional right to that. There's also not a constitutional right, which is inscribed in the dismissal statutes, to have full-blown discovery before someone can be terminated like you would as if you were in a civil lawsuit. Nor is there a constitutional right to have attorney's fees provided to you in the event that the effort to dismiss you is unsuccessful. So let's not conflate a constitutional right like the right to equality of educational opportunity that every child in the state of California has, with what are statutory rights that are in excess of due process and that are not constitutionally required. That's a very, very critical point in terms of understanding the balance of what we're focused on here. And so, again, you know, the main point, and I said it at the outset, is that people are clear that this needs to be streamlined, because if you have something that's so heavy that you can't lift it, the net effect is that you're essentially being complacent in terms of having ineffective teachers in the system. Now, I talked about LIFO and the seniority-based layoff system. Just to give you a few examples here of something that further underscores this. One of the things that you hear is, well, the difficulty with having a layoff system that isn't based on seniority is, how do you eliminate arbitrary determinations? How do you eliminate, you know, someone just randomly or subjectively making something up? As if there is a rational correlation or absolute correlation between seniority and effectiveness. How many people believe that just because a teacher has more years of experience, that they're by definition more effective? We all know that's not true. How many people believe that just because someone starts out and is a relatively new teacher, that they're inherently less effective? We know that isn't true. What we're talking about, again, is this: not being afraid of quantitative and qualitative information. And since you collect data on teachers, and since we have data on students, combining them so that rational decisions can be made, and so that rather than sort of, again, on a quality mind basis, determining who should stay in a school and who shouldn't, who should be in front of kids and who shouldn't, you actually use that data of people's impact on students to make that determination. Seems logical. Yet in Sacramento, the teacher of the year was laid off under LIFO. And in 2009, there were quality mind layoffs under LIFO and LAUSD. You had 2,000 English teachers and 1,500 math teachers in the lowest quartile of performance. They got to keep their jobs. Thank you. 20% of the English and math teachers were laid off at the top quartile of their job in terms of performance. And again, I talked about the disparate impact on black and brown students as well as low-income students. Part of the problem, and this was something that we saw in the Reed case, and if you guys don't know that case, I commend it to you. It's a case that was in LA Superior Court. The judge had an observation that there were going to be layoffs that were going to disproportionately affect a certain number of schools. Disproportionately affect would be, again, a charitable way of putting it. It was basically going to cut a huge hole out of the teaching staffs in those schools. And what some of the studies showed is that those schools, those most challenged schools, are the ones that tend to suffer the greatest numbers of layoffs because they tend to have the more junior teachers. They also tend to have the more inexperienced teachers, so that you get what? You get a churning effect that destabilizes the environment because you have a high rate of teacher turnover. And just one more point here. And in the interest of time, again, I talked about this disparate impact point. I just want to wrap up by flipping through here and talking about what it is that what we're asking the court to do in the case. To affirm that the challenge statutes are unconstitutional for the equal protection violation that we talked about. To enter a permanent injunction prohibiting the enforcement of those statutes. And to prevent the defendants from implementing any similar laws as a workaround. In other words, you get an injunction that basically prescribes that unconstitutional conduct. You don't want to have that circumvented by laws that basically do the same thing. And to retain jurisdiction until the defendants have complied. So, is that it? Thank you. All right, thank you. And by the way, I'm happy to answer any questions about this, and as I said, I know that it was very quick, so if you have any questions, just let me know.
Mr. Erickson, would you like to see if I can do this one? Sure. Actually,
Escape.
it's what?
Escape.
Escape. Josh,
Thank you. All right, so my name is Seth Eckstein. I'm an attorney, labor and employment at Oakland Unified School District. Thank you, Joseph, for having me here. Let me start off by prefacing that although I'm discussing dismissals, the district strives to work with teachers whenever possible to remediate deficiencies. And I can tell you, I used to be a teacher. I know that teaching is a tough job. But I also know from that experience that, and I don't think anyone would disagree, that sometimes not everyone is cut out to be a teacher. And in those cases, sometimes staff will leave on their own, but that's not always the case. And if that's not, that's typically when you move for dismissal. And we do so because that's in the best interest of children. Second, for context, let me add, at least in terms of Oakland Unified, the number of teachers that we're talking about on the dismissal track is relatively small. About 3 or 4 teachers per year. And the cases that we're bringing tend to be the ones that are involving teachers that are particularly ineffective. So with that in mind, what I'm here to do today is talk a little bit about the dismissal process. We've got a little bit of background already talked about as it relates to the Bedard case. I'm just going to walk you through, I'm actually going to do my best not to editorialize and just leave it up to you to decide whether let you develop your own opinions on the current model. So the dismissal process for certificated employees, that term certificated refers to teachers. So in California, the teacher dismissal process is governed by the California Education Code and various court decisions. There's 44932 and 44939. And then there's various case law. So this is 44932. Just basically, if you're going to work for dismissal of a teacher, it has to be one of these enumerated reasons. Over time, the court cases have, I think, melded a lot of these factors or these subsections to really the standard being whether or not the teacher is unfit for teaching, unfit to teach. And that requires a demonstration of various, over time, a showing of attempts to remediate if possible, and ultimately not being able to do it. So 44932, there's also 44939, a lot of them overlap. Interesting, the Communist Party was actually listed in there, but no one I don't think is nowadays Morrison Factors, these are the factors that the district generally has to prove, not all of them necessarily, but those that are applicable in trying to move forward, showing a teacher is unfit to teach. So, first step, when we are looking to possibly consider some sort of discipline, first one involves some sort of remediation efforts and notice. Notice is actually required for 2 major grounds: unprofessional or immoral conduct and unsatisfactory performance. When you write these notices, they must include all the allegations with specific details. I can tell you, just from the ones that I've worked with, they're very time-consuming to write. That's especially true for notices of unsatisfactory performance, so NUPS, is what we call them for short, where you need to identify each standard that the teacher isn't complying with, and include data to show that. So a good NUP will usually rely on 2 to 3 years of attempted remediation, which includes multiple years of unsatisfactory evaluations and unsuccessful performance in a coaching program called PAR in our district. I'll be honest, it's not uncommon for teachers to get defensive and blame poor performance on perceived bias of the evaluator. So a lot of times we actually have multiple administrators to try to counter that if that comes up. So once we've given notice, if they haven't demonstrated remediation, the next step is a statement of charges. This is written a lot like a plaintiff's complaint. It's on pleading paper, and here the district has to identify precisely which subsection of 44932 and 44939 the teacher violated, and include concrete facts with each one. So thinking of a plaintiff's complaint, when you're moving for dismissal, you're relying only on the 4 corners of this statement of charges. And there's incentive, therefore, for the district, a lot of times to sort of throw in the kitchen sink. You're trying to include everything that could possibly come up later on at a hearing. Because it's so comprehensive, it takes a long time to write. Usually, for me, when I'm involved, it's about 2 days of straight writing, assuming that the person who's writing it knows what they're doing. Oftentimes, school districts outsource this to outside legal counsel. The last one I assisted with is about 250 pages long, to give you a sense. And I don't think that's abnormal. I think a lot of them tend to be fairly long. So once the notice of, or rather the statement of charges are issued, the employee has 30 days to request a formal hearing. The district then files formal accusations, and then a clock starts. And the district has 60 days from when the request for hearing is received to actually start or commence the hearing. It's actually very hard to get a hearing started in 60 days, so it's usually stipulated to a longer time frame. So there's another point after this, which is called the settlement and pre-hearing conference. I'm going to skip over that for a second, I'll come back to it. Let's talk about the hearing itself. So in the hearing, you have full discovery. Typically, the scope of discovery for administrative hearings is limited to discovery that's provided under the APA, the Administrative Procedures Act, that's the abbreviation, which is fairly straightforward, fairly basic. However, under the Education Code for dismissal cases, full discovery is permitted. That includes form logs, so form interrogatories, special interrogatories, request for admissions, request for protection of documents, and depositions. And I know I said I wouldn't editorialize, but I do want to add one point that in my experience, this is an area that's caused that we see a lot of abuse by teacher counsel. In the past year, we spooled up dismissal cases, and I was just doing a tally of the special logs that were asked. So just out of give you a little challenge here. How many Civ Pro buffs here? How many special interrogatories under this California Civil Code of Procedure are you normally allowed? Does anyone know?
You don't study California Civ Pro.
You do? Oh, okay. We're doing the bar. 35, that's right, 35.
Came from the audience somewhere.
Someone say 35? I'll send a note to your Civ Pro teacher. So it's 35, but, here's the but, if the lawyer includes a declaration that more are necessary for the case, they can actually put as many as they want. And then that puts the onus on the responding party to either meet and confer, and then file a protective order and go to court to try to get that number limited, or to just respond. So again, we said 35 was the limit on the California Rules of Civil Procedure. So the cases I just happened to look up for this year, one had a special log request of 118, the other had 265, the other had 165. And basically a lot of them are, in my experience, are just what are called contention interrogatories. Like, do you contend that XYZ teacher did this? And a lot of times these are actually what we contend are in the statement of charges already. So there's a lot of just repetitive yes. Unduly burdensome questions, a lot of objections. It takes a long time to write. Again, something where you need to be pretty savvy, you need to have just legal counsel to respond to those. My experience is those usually take about at least a week to prepare, provided you have the information that they're requesting. If they don't, for example, if you're doing performance dismissal, a lot of times they'll say, well, show us all the teacher data or standardized testing data for that teacher and all the standardized testing data for all the other teachers in the school so that we can compare whether or not this person really is performing well. And do that for the past 4 years. And that actually, if you do have it, it actually takes a very long time. Yeah. So that's just wanted to point that out. Other than discovery, you also have depositions, which tend to be very expensive. Court reporter's time, copies of transcripts tend to cost around $200 to $500 for each one. Depositions, in my experience, are very tough on witnesses. They need to leave work if they're working. It's very stressful to testify under oath, and they can be asked very probative questions, and sometimes they feel like it's punishment, which I think in my experience, sometimes that's been a discouragement for them to participate in future hearings. So the hearing itself, rules of evidence apply. Hearsay may be used to supplement, but can't be itself support a finding unless an exception applies. I mention this because this is actually a big challenge for the district when the witnesses are children, because if the misconduct is something that's observed by children in the classroom and no one else is around, the only way we would get their statements in would be through having them testify. And that's actually something we just really don't like to do. Sometimes children don't remember. They may not be comfortable saying things about the teacher. There's actually a case where we had a teacher who was a yeller, and we deposed one of the children, and we asked, how does she treat you? And the child said, oh, she's nice. We're a really tough class, and I feel so bad for her. She yells so much at us. She's going to lose her voice. And I just thought that it was cute, but it was also very sad that the position that the child is have to testify about the teacher. It also can be really traumatic if something bad happened for the child to revisit painful memories. And that happened this year where there was a student who was so upset about something the teacher did that he was claimed to have been suicidal, and he was in elementary school, and trying to get him to testify, I was like, we weren't ready to do that, and have him relive these awful experiences. The scope of hearing is the standard. Just talking about the scope of hearing, the standard is the district must provide its case by preponderance of its evidence. Allegations are limited to the past 4 years, so you can't use any information that goes more than 4 years from when the statement charge was filed. The panel who's actually going to be making the decision consists of 3 people, an administrative law judge and 2 people who must hold a valid credential and have at least 5 years teaching experience during the past 10 years in the accused teacher's discipline. So that's actually fairly specific, and the times that I've been involved in trying to find a person who fits that category, we actually have a very hard time. Beyond that, our experience has been that panelists have a hard time finding fellow teachers guilty. It's really not clear why that is to me. Evidentiary restrictions, legal standards, subjective nature of allegations. Sometimes when you say someone's not performing up to par, that's up to interpretation. And another one, maybe, and this is me from having been a teacher, I wonder if there's an inclination towards just not giving up on a person. I think that's definitely when I was a teacher, that was a mindset that I grew into, and I wonder if that carries over, but I don't know. I can tell you that the district has only won 2 of the 10 cases that went to hearing in the past 10 years. We talked earlier about hearing costs. So the district must pay all court fees. If the district loses, the employee is entitled to attorney fees, which can range from $100,000 to $200,000. Full back pay, if the teacher was out on pay, and a job placement back in the district. So the stakes are really high. Okay. So all that being said, I was mentioning the pre-hearing conference and the settlement conference. Before a hearing commences, the parties must come together. And meet with an ALJ to discuss settlement options. And that's when most district cases are settled, in my experience. Almost all of my cases settle at that time. That's essentially a risk assessment. It's a huge investment of time and money. Losing a dismissal case can cost the district upwards of about $400,000. You're factoring in its own legal costs and having to pay the teachers legal fees plus reinstatement. It's very difficult to get witness participation, difficult in prevailing, like I mentioned before. And there's a huge risk that if the district loses, you could have the teacher coming back who you don't want to come back. And there's also the chance that the teacher will appeal. So just quickly, generally speaking, we'll agree to a settlement. I'm just going to give you a sort of a typical settlement involves paying the teacher around 1 to 2 years of salary or benefits. So we're talking about $80,000 to $100,000. They push a lot for non-disclosure to future employers. We because I think they have a stronger bargaining position because of the restrictions that's often agreed to. And lately I've seen a lot of pushback on reporting to CTC, the Credentialing Commission, making requests that the district make some sort of arrangement whereby the employee resigns in a certain way that we don't have to disclose conduct to the commission. And then for all of that, the teacher agrees to resign and they won't do that. So that, in a very quick nutshell, is the dismissal process.
Okay. Hi, everybody. So I'm Laura Duran. I'm the Legal Director of the California Teachers Association. And before I was in this position, for 9 years, I was at a labor and employment law firm in San Francisco representing labor union workers and employees in labor and employment matters. And an initial sort of disclaimer, I think, is in order. I'm not necessarily speaking here on behalf of CTA today. I'm going to give you my own views based on my own experiences and knowledge in these areas. And the other thing is I'm not actually going to spend a lot of time on the Vergara lawsuit for a couple of reasons. And one reason is that we're in the middle of ongoing litigation. Summary judgment papers are being drafted as we speak. And there's a lot going on in the case. We're in the midst of discovery. I don't think it's appropriate to be arguing the case or getting into the details of the case in a classroom like this when we're in Florida for these matters. But also, importantly, I think Vergara is a distraction from the real issues that we're dealing with in public education today. We have a lot of serious systemic problems that we should all be working on, and that's what I actually want to spend my time discussing today. I mean, Vergara fits into it does dovetail with the tax and public sector unions in general, and represents one piece of the corporate reform narrative, and part of that narrative, which you're all hearing about, frequently in the media, is that public schools are failing and teachers are the problem. Teachers are to blame. That's a false narrative, we think. So listen, let me talk about that a little bit, but I will briefly mention a couple of things about Vergara. The main thing is we don't think that the statutes being challenged in the case are the problem. We don't think they're a problem. And in fact, there's no evidence to suggest that if you just eliminate these statutes, that magically the achievement gap is going to close. In fact, that's not going to happen. That wouldn't happen. And a lot of the evidence that Mr. McGray was referring to and the like are all based on this notion that student test scores somehow are a reliable and valid measure of teacher effectiveness. And the various challenges and complaints we're hearing about the statutes are all dependent on this notion that we can objectively calibrate, I think was the word that you used, or that value-added models are a reliable and valid measure of teacher effectiveness, when actually the research shows that they're not. There's a ton of research out there on this, and and researchers agree, everyone agrees who studies this, that certainly standing alone, using student test scores and value-added models are very unreliable and telling us anything about teacher effectiveness. But there are also researchers who will tell you that these models are deeply flawed and don't really tell us anything actually meaningful about teacher effectiveness, and we certainly should be making high-stakes employment decisions based on these models. And so the other thing I want to say is putting this in context. If you actually look at the national picture, where students actually perform the poorest on the National Assessment of Educational Progress, is NAEP. It's a national test that's administered. Students perform the poorest in high poverty states. That's where the correlation lies. So, and the states where teachers actually have the greatest due process protections are where students perform the best. And we actually think that eliminating due process protections for teachers would be counterproductive. Because we think that actually the problem we're having, and I'm sure Seth's going to attest to this, is that we're unable to retain teachers in the profession. We're having enormous difficulty recruiting teachers and retaining them. And making the teaching profession less secure and more vulnerable to the whims of administrators, administrative abuse and the like is not going to attract folks to the profession. Eliminating academic freedom. Tenure is really an academic, part of why is what people will refer to as tenure is something that has evolved over the decades, is that it does provide some level of academic freedom to teachers. And it's not like tenure in higher education, where once you get tenure, you're really pretty well locked in. It's not like that. The way it actually works in California is that the probationary statute, when you're a probationary employee for 2 years, you're completely at will. You're completely at will. You can be terminated for any reason at all. You can be non-reelected because they don't like your hairstyle, and the administrator doesn't have to tell you why they're not reelecting you. So you're entirely at will. It used to be in California, these laws have changed over time, by the way, is the legislature is striking a fundamental balance, balancing what we need to recruit teachers and provide them due process rights, which are constitutional rights, we believe, and balancing that against the needs of school operations and the like. That the legislature has been striking that balance and has reconsidered that balance over time. It used to be, actually, in California, that probationary teachers received actually a hearing. It's akin to a Skelly hearing before they were let go. They couldn't just be terminated for no reason at all. That was changed, and when they went with the 2-year probationary period, they gave districts complete discretion to non-reelect probationary teachers for any reason at all. And it's not a job for life either. When you attain permanent status within a district after 2 years, you do get all these due process protections. That's what you get. It's not, again, like in higher ed, when you think of tenure in the sort of the higher ed context. It's not the same. And we think that the dismissal statutes, were designed to prevent. They didn't just sort of magically just sort of appear, right? There was a lot of favoritism, there was nepotism, there were abuses that were seen as real problems. And so in part, those protections were designed to prevent the unjust and arbitrary dismissals that people had been experiencing. And just in response to a couple of the points that were made here, relying on a handful of kind of outlier cases and what LAUSD happened to spend in a couple of extraordinary cases doesn't really tell us much about sort of systematically how we should be approaching things. Other public sector employees, by the way, tend to get just cause protection or something similar much sooner than 2 years. And for that matter, in the private sector, when you're in a unionized environment, you tend to get just cause protection much sooner. Your probationary period tends to be much less than 2 years. And so, again, and the other thing, and as Seth pointed out, really, relatively few dismissal cases actually go to a hearing. The vast majority of them settle with a teacher leaving the district. That's the reality. And in terms of the layoff statutes, the reduction in force, we call it the RIF statute. It talks about reductions in force. That process is far more nuanced than has been described. There is a seniority principle, that there's a reverse seniority principle embedded in the statute. But the way the statute actually works is that the district, first of all, makes decisions about what services they're going to cut. So the district has discretion to decide, okay, we're going to cut PE, or we're going to cut art, or we're going to cut whatever. And they make all of those decisions, and then they decide, then they identify what are called competency criteria, where they say, okay, we're going to decide to be competent to teach a particular course, say math or what have you. You have to have taught the course for, let's say, within the last 8 years. Let's say, as an example. So the district will come up with these competency criteria. And then they'll skip folks, who are junior teachers who have certain credentials, who meet the competency criteria, and in some cases have special training and experience that the district thinks is necessary to teach a particular course or course of study. So one example of that one with the Board of Appeals were community day schools. So, a district skipped junior teachers who were teaching at community day schools. That was held to be permissible. You didn't have to retain a more senior person. So my point is that it's a much more nuanced process, and it's not a strict last in, first out process. And the other thing is the statutes, they are enforced every single day in California. They are enforceable, and they can be enforced, and they are enforced. And LAUSD, excuse me, I have a cold, so I'm trying to take care of my cold while I'm talking here. LAUSD is an interesting example because when Superintendent John Daisy took the helm of that district, he dramatically increased the number of non-reelections, and non-reelection is probationary folks who are not kept on, who are let go. He dramatically increased those numbers and dramatically increased the number of terminations in the district. Now they're terminating many hundreds of teachers a year. And the statutes haven't changed. What changed in LAUSD was John Daisy showing up. New sheriff in town is sort of his approach. And that's his prerogative, and that's so. But the point is, it's not that the statutes, are workable. They can be enforced. And the other thing is, teaching experience matters. And part of what the layoff statute is reflecting is that experience actually matters. And I think it's a matter of common sense. If you had a choice between having your child being taught by a first-year teacher or a teacher who's been teaching for 8 years, you'd be crazy not to pick the 8-year teacher. Would you pick a lawyer who's someone who's right out of law school, or someone who's been practicing law for 8 or 10 years? You're going to pick the person who's been practicing law for 8 or 10 years. Same with the doctor. I mean, it's just because we all learn. It's not to say that, in some cases, sure, some people over time, for whatever reason, because of life experiences and the like, maybe lose their momentum or what have you, and you might have someone who has a tremendous amount of promise in the beginning. But even folks who are fantastic teachers in the beginning, they have an enormous amount to learn. It's an incredibly hard job. I mean, anyone who's taught will tell you that the first couple of years in particular are brutal. And there's this kind of contradictory notion that's also kind of part of this corporate reform agenda that, well, we need to make sure we have enough experienced teachers in our neediest schools. But on the other hand, experience doesn't matter. I mean, so which is it? I mean, experience, does matter. And the seniority statute reflects that in part, that folks who have been teaching longer are just more likely to be, good teachers. There's a lot of wisdom that comes from experience. And again, the real problem here is teacher retention. I mean, Seth can tell you this, that in Oakland Unified, they lose 76% of their teachers within 5 years. 76% of their teachers leave that district within 5 years. Isn't that the problem we need to be talking about? So those are the kind of problems we need to be dealing with. And turnover costs that are associated with all of those folks leaving the district, or in many cases leaving the profession entirely. And we actually think that the statutes being challenged in Vergara make the profession more attractive and help retain folks, and that benefits students. I was a little surprised when I first got the invitation to speak today on this panel, because it was sort of configured as sort of free market, how the free market can help close the achievement gap, and that corporate reform narrative or frame really is quite different than sort of my own philosophy and my own sort of beliefs around public education and what the purpose of public education is. I don't know whether John plans to address this at all. But public education is a collective obligation. It's a collective responsibility. It's not a consumer good that we ration. We all have a responsibility, and the California Constitution, in fact, requires the state to provide all students in California with a free education and provide a common school system. I'm not going to spend any time right now talking about some of the sort of problems with the corporate reform agenda. If you are someone who's interested in that, I highly recommend Diane Ravage's latest book, Reign of Error, where she walks through each sort of piece of that corporate reform agenda and debunks the myths associated with them. And there's, she also talks about, who's funding it and who all the players are and what role ALEC plays in this and the like. But I don't want to spend any time talking about that. I want to talk about kind of, again, what kind of solutions we need to be focused on. And there's not a zero-sum game here. I mean, one of the things I think that the teachers in my organization are really frustrated about is that it gets portrayed as this kind of teachers versus students, as if their interests are not aligned, when that's not true. And teachers very much believe that their interests are aligned with students, and that's why folks choose to become teachers, and particularly public school teachers, because they believe that it's really important, that it's essential to our democracy that we have a functioning and healthy and well-supported public school system. And I believe that as well. And the goal really should be in all of this is to make sure there's a great public school for every single student in California. That's the goal. It's not about having winners and losers, and some schools are going to be winners and some schools are losers. We want every public school to be a winner. That should be the goal of public education. And so with that, let me talk just a little bit with the time that I have left. Okay, all right, I'm going to talk really quickly, which I do usually anyway, about what we really need to be talking about. So basically, there are two big frames here, folks, okay? If you want to be a progressive lawyer, this is a progressive lawyering conference, right? You need to be dealing with all of the societal, structural issues that make it very hard for a lot of families and a lot of students to succeed. We need to be dealing with poverty, we need to be dealing with racial segregation, we need to be dealing with opportunity gaps and income disparities. Opportunity gaps between rich kids and poor kids. And then we need to be talking about the school sites and what we can be doing within the schools to improve school and learning for everyone. You know, and on the societal stuff, you know, it's in California, 54% of public school kids are poor or low income. Okay, over half of the public school children in California are poor or low income. Okay, and in 17 states in the country, the majority of kids are poor or low income. Okay, that's the reality that we're living in. And if you're not prepared to you know, deal with poverty and the effects of poverty, then we're not going to make any progress towards achieving equality and helping close the achievement gap. And in California, we also have, you know, about a third of our students are English learners too. So that's again an additional challenge for us here in California. And there's been a lot of research done on how income, Sean Reardon here at Stanford, for example, has done work on this, about how growing income disparity has meant that very rich families are not only have a lot more in terms of what they're, you know, in terms of where they're at, but they are devoting it to enrichment and early childhood kind of development that is having enormous benefits for rich kids. And poor kids are not getting that opportunity. So we should be, you know, if you want to shake some foundations, shake the tax foundations. We need to shake the Prop 13 foundation. Deal with tax fairness issues. Support minimum wage increases. You know, support policies that are designed to help families have health care for them and their children. Make sure their food secure, and that there are that push government and business entities to have family-friendly policies so that parents are able to have affordable daycare. You know, these are issues that, of course, the unions have been working on forever, so I'm happy to be talking about them in this context. But we need to be dealing with all of those things, including racial segregation, residentially and in schools, if we're going to start dealing seriously with the effects of poverty and helping kids show up to school ready to learn. And then in terms of schools, I mean, a lot has been written about this, that we actually know what great schools look like, right? A great school has small class sizes, has a committed staff. It has a lot of resources, well-maintained facilities, right? They have a varied curriculum with lots of school activities. They have after-school enrichment programs, and a variety of real depth to the curriculum too. You know, they don't just focus on reading and math. They make sure they hit all the subjects and teach a foreign language. We know that that's what great schools look like. That's what we should be creating for every public school in California. And John will be addressing the really shameful deficiencies in the resources in California and our California schools and the litigation that we've been involved in about that. But if we don't provide those resources, we cannot provide what students need in the schools to succeed. And there was a lot more I was going to say, but I'll need to say that I'm running out of time. So let me say one more thing about in terms of teachers. Teachers do need to be well prepared, well trained, and well supported in schools. Members of my organization take great pride in being professionals and knowing what's going on with every kid in their classrooms. But they do need to be well supported in schools as well. There need to be counselors there to help with students who need have special needs and the like. All of those things need to be in play. And we need to value teachers. You know, and right now it's a really tough sell to tell people, oh, you should go into great debt to get your degree, to get the training you need to be a teacher, and then we're going to pay you poorly, and then it's going to be a really, really hard job, and then you'll be criticized and held accountable for your students' test scores. I mean, that's not a great way to attract people to the profession. And if folks are interested in using sort of free market principles, use them here. I mean, how does that incentivize folks to come into the profession and stay in the profession? A lot of people think it's a noble calling, and they really care, and they choose to do it, notwithstanding the challenges. But we really need to support our teachers and ensure that we have, there's a bunch of other things too, early child, preschool, we need preschool for all as well. And so there's a lot of components to it. Sorry, I'm out of time, but it's critical. These are all essential things to be working on if we really want to improve public education. Thanks.
Good afternoon, everybody. My name is Josh Mubabat. I am in-house counsel at College of Education. We're a relatively new charter school network. We have 9 schools and just over 5,000 students. I'm going to talk a little bit more about, provide a little bit more background about my organization on the next slide. But I first want to talk a little bit about the California Charter School and talk a little bit about my personal connection to this debate. And what Joseph has asked me to do is sort of provide the perspective of charter schools, which are not constrained by the statutes we're talking about in Vergara and some of the other related litigation, and what charter schools have done with that flexibility. And it's impossible to generalize about charter schools. There are good ones and there are bad ones. California's charter school law allows thousands of flowers to bloom, and there have been some high highs and low lows. So when I say charter school, I mean mine, not anyone in particular. You can read great things and horrible things about charter schools across the state, and I think most of those things are true, great in the world. Personally, I was, as people in this room and this panel, a teacher. I attained permanent status, and I was let go through the LIFO process. So I have a certain perspective on that. My partner works at a labor and employment firm. They actually do contract work for CTA, so my home life is very filled with this debate on a continual basis. But I just picked out 2 segments of the ed code that comprise the charter school law to kind of get you up to speed from my perspective. One is the legislative intent, which is the first bit, 47601G. Charter schools are intended to provide vigorous competition within the public school system to stimulate continual improvement. That means kind of whatever you want it to mean. Does it mean the state has given into the corporate reform agenda? Perhaps. Does it mean that it's difficult to remove other constraints? So one way to push instead of pull is to provide some other competition within the system. Decide on your own. The way I think about the sort of continuum that's been laid out by Marcellus and Laura is that, I think people of goodwill can agree that the system would do better with more resources. My question is, when will more resources be available? And in the meantime, what should we do, if anything, to try to get better outcomes to save inputs? And to that end, 47610 is what in my industry we call the mega waiver. It presumptively waives charter schools from almost all of the ed code, including the statutes at issue in Vergara. And my self-serving take on that is it leaves us free to operate with fewer constraints and to innovate freely. Somebody else might say it leaves us free to be arbitrary and capricious. Both of those things could be true. So a little bit about my organization. We're a charter school that was founded back in 2007. We've now grown to a network of 9 schools. We have most of them in San Jose, but we opened up our first affiliated school out of state in August. Our student population is almost entirely low-income and English language learner. That's what our academic model focuses on. And our organization's exempt purpose, very grandiose, but it's stuck in our bylaws, is closing the achievement gap within our lifetimes. And the sort of pillars of that are focus on individualized instruction and blended learning. We get students who are, we open the schools that are full, so with 5th graders who are often far below grade level, and kindergartners who've never been to preschool, and everything in between. And talk a little bit more about what the model does for that. Parent empowerment and building a talent pipeline that deals with one of the issues that Laura mentioned that I agree is a huge problem, which is retention. We have a problem with retention as well. We retain, I think, about 2/3 of our teachers, not even within the first 3 or first 5 years, but the first 3 years. So again, very grandiose plans in our bylaws. So the 3 pillars that our management is always harping about or reminding us about are maintaining quality. Without quality, you shouldn't even be thinking about figuring out how to scale. Without having figured out how to scale, you shouldn't even think about growing. We have, as I said, 8 schools in California right now, and we have more than 20 charters to open new schools if we're able to meet all the requirements and find sites for those schools. We have 8 charters in Wisconsin, and we have more in other states and are applying for more in other states. A little bit about human resources at a charter school. So as I said, charter schools are exempt from most of the ed code, including everything that the previous panelists have discussed. So our employees have the basic state and federal employment law protections in place, and they can collectively bargain. I've not yet done so, and there's a very high bar to bargaining in place with lots of turnover, so I can imagine why it's not a terribly attractive place to organize. all our employees, including me, are at will. We pay a little bit higher than districts, and then with incentive pay quite a bit higher than districts. Benefits are pretty similar, though premiums and deductibles are higher. The retirement benefits, I would say, are better because our teachers are members of the defined benefit pension system, as well as having a 403B match. And as you might imagine, for some of the extra resources that are put in, expectations are higher as well. There's a longer school day, shorter summer, and a lot of mandatory professional development. None of these things are things we had to negotiate. We imposed them unilaterally. Take it or leave it. So our staffing model, again, take it or leave it. These are the terms of employment. Like it or leave it. The credentialed teacher should be able to focus on the highest value instruction, and that is individualized instruction, since kids come in different places. And getting people up to grade level is something that's more efficiently done through support staff and technology. There's continual coaching and benchmark testing for all staff, both credentialed teachers and non-credentialed support staff. And the staff are deployed in a way to sort of maximize their impact, which means changing the schedules around during the year. Again, something we don't have to negotiate. The staff are deployed in a way that best suits their strengths, and their strengths are continuously measured. We have 6 testing cycles a year. We just finished the first 2, and now there's some redeployment going on based on what came out of those first 2 cycles. And we're always trying to improve our school model based on the data. Again, this is something we don't have to negotiate with any employee group or respect any statute. We do what our management thinks is best. It drives some of our employees crazy and they leave, but we like to think we do what's in the best interest of the students. Your charter school is only as good as its enrollment. I have not mentioned how our schools have performed. You can look that up if you want to, because I don't really care. The measure of performance to me is that our students stay enrolled there when they had to make a choice to go there in the first place, and their parents and guardians are people who are predisposed to making a choice for their students' education, and so could just as easily leave. So if we keep our enrollment, if we keep a wait list, it means we're doing well. That's all I want to say about HR and the Vergara situation. I'm going to foreshadow a little bit some of the finance issues, which are not nearly as interesting, so I'll be brief. The charter schools are public schools, and they access largely the same funding. They have to pay a little bit of oversight from their public funds to their charter authorizer. We pay 1%. We don't have access to certain funds that traditional public schools do have access to, certain parcel tax revenues and construction funds. So we have to privately borrow money on the private market to build our schools. We don't get the state funds. And charter schools often raise a lot of money for philanthropy. And the amount they raise, and the things they use it for varies between schools. So generally, any changes that would benefit traditional public school with a heavy English language learner, low-income population is going to help drive. So the changes that were sent through this year, the local control funding program, Governor Brown's initiative to reform how school funding works, that helps us. And so this is our budget philosophy, that in order to grow, we cannot rely excessively on philanthropy. So public funds need to pay for school operations and the prorated share of administrative costs attributable to that school's operations. And if public funds can't pay for that, then we need to change our model to get it to a place where public funds can pay for those services. We have some extra flexibility compared to traditional district schools. Again, because of the waiver, we don't have to deal with certain bidding and prevailing wage requirements, and that generates cost savings for us. And philanthropy we use for one-time expenses. So curriculum development, expanding to new states, shouldn't be using public funds. And that's just wanted to stop, and happy to answer any questions.
All right. Well, this has been a very interesting discussion. And I think I'm only going to touch on at a very high level sort of RR versus union issues. And the charge that I had was to sort of talk generally about my work in education reform and how we approach it. I'll try to intersect that with specific HR issues that come up today. But I think what I see and have tried to respond to in my career is sort of two strands. Basically, that there are serious resource equity issues, resource adequacy issues in public education. I think we do ration education in this country. We don't have to. It is a common good, and we can deliver, and should be delivering a high-quality education for everyone. It shouldn't just be Sean Reardon's research supports those who are coming from better-off families getting better-off education. On the other hand, I think it's not only about resources and putting resources in the system, but it's also about effective use of resources. And I don't think it's an either-or, and I think you need to think about both ends of both components to good systems. And that's really what I think we need to be thinking about, is how do we create good systems that are going to produce high-quality opportunities and good outcomes for students, regardless of their individual backgrounds. I think a major sort of missing component from our system is that, and I don't think the kind of narrow focus of Vergara on these 5 statutes is going to flip the switch and get us there. I think it's much broader than that. We do not have a system in California and in general in the country for developing high-quality teachers, supporting them in our schools, evaluating them, and retaining them. And it's that through line that we really need to develop and invest in as a country and as a state. The modal years of experience in America for a teacher, modal being that just as many people above that line is 1 year of experience. And 20 years ago, it was much closer to 12 and 15 years of experience. We have made the teaching profession much less attractive because we don't pay them enough, because there have been these, no child left behind and other pressures that put a lot of accountability and focus on teachers without a lot of support to help them perform. For whatever reason, you can just look, teachers have been voting with their feet. They don't get prepared. It's too stressful. The pay's not good enough. The supports aren't there. And you're seeing a churn of young teachers come in without a lot of experience, and experience does matter. And I think the research does support that. Certainly through these 5 years of experience, 5 to 10 is sort of ideal, 5 to 8 to 10. After that, experience sort of tapers off. Some people are going to get worse, and some means it's just a plateau. But certainly, having teachers who are 1, 2, 3 years of experience in the lead is not a good recipe for a long-term solution. I think the country of Finland does. It's a small country. It's much more heterogeneous than America, but they have built. They used to have a more inequitable system back in the 60s and 70s. And there are poor people in Finland, and there are immigrants in Finland. And they used to have much more disparity in their test scores. They changed their education system and said, you know what, we don't want a rational education anymore. We want we're a small country. We don't have resources, natural resources. We have people resources. And we have to develop those. That's the only way to compete with the economy. They looked at America and said, let's adopt those ideals of giving everyone equal opportunity. How can we implement that? And one of the major things they've done is develop their teacher system. First of all, they paid them very well. You don't have to get paid you don't pay to go to school if you get selected. It's very competitive to be selected into the schools of education, and it's a free ride. And they get the top 10% of folks in the country that decide to be teachers. Once they become teachers, they are supported at their schools and with enough resources to deal with the array of students that they receive. And they're given a lot of freedom about what curriculum and how they're going to design it, and a lot of teacher collaboration time to support each other and their improvement, learning communities, etc. The difference between test scores across the country is 5%. Among the highest in the world's firms. There's a very even, high quality outcomes coming out of Finland, and they consistently score at the top of international assessments. So, that's the kind of system I think we ought to be developing in this country, where we do make teaching more attractive, where we do invest in prepare future veterans, where we do make sure our schools of education are attracting the best, and that they're doing a good job educating, they're not closing down, and we are providing our schools with enough resources to make these positive learning communities, and then we're evaluating teachers along the way. I think the evaluation thing, there's a lot of energy that's focused on, how do we get rid of that bottom 5%? And, Eric Henshak, has this, theory that well, if we just got rid of that bottom 5 or 10%, our achievement scores would shoot through the roof. I don't think our research really supports that. And I think the energy ought to be focused on that middle part of the curve. You saw those yellow teachers who are not the best, but they could get better. Because that's the biggest chunk. And we don't have an evaluation and support system, professional development system enough in our laws and our practices to help teachers improve, because they do want to, and figure out which ones of those yellow ones really can't improve or don't want to improve, counsel them out of the profession, and which ones do. Most of them do. But we need to be much finer right there. I think the best system I've seen in California, frankly, is a union-run system down the highway, which is where the district and the union have worked very closely together and turn the evaluation system over to teachers. And the district has their seat on the panel and deciding a lot of the issues, but the majority of teachers. The teachers don't want bad teachers in their system, and they counsel out a lot of teachers once in a while and support the ones that want to grow, to work. I've been down there because that it seems like that's not the only way to do it, but I think we need to be doing a better job in evaluation and support, and that's what I energy. In terms of the resources in the state, how much time do I have?
Got around 5 minutes.
Okay. So in terms of the resource side of this, and California doesn't have enough resources in the system to pay its teachers properly, or to provide all the supports that we ought to be providing to deal with poverty at schools. I also should say, my son goes to a high poverty school. 5% or so of our students are free reduced lunch, and I'm on the school board. So I also have a perspective of kind of being the employer, overseer, as well as the outside advocate. And it's so I just kind of come at this two ways, and it's been helpful for me to see that different perspective. But it is true, we don't. The things that work well in our elementary school that we haven't carried over to our high school yet is really having the coach, kind of the instructional evaluator that work with teachers on each different grade level collaboration, identify who the students are that are not on task and not keeping up, give them extra support, pull them out. The principal can't do that. We've invested to have that person at our elementary school. We've cut so many administrators from our system that we don't have enough people to competently deliver the product. California, 49th out of 50 states in terms of its per pupil budget. In terms of staffing configuration, teachers, nurses, counselors, administrators, we're 50th out of 50. We're the worst in the country. We don't have enough adults in the system. We could have smaller class sizes, sure, but it's also having the nurses and the counselors. And as I said, these other people like coaches or administrators to help build that kind of professional development learning environment. I really seem to make a difference. When we brought the Williams case, we did some of the first surveys because the state was asking these questions. Statewide surveys of teachers. Do you have enough books in your classroom? And your kids, can you take them home for homework? And what kind of facility conditions are you seeing there? The teachers report, a third of the teachers told us they did not have enough books for their kids, every kid to take one home. And 11% of the teachers said we don't have enough in classroom. And 25% said, yeah, I've seen evidence of mice or rats or other rodents in the school. 15% of them said our facilities are really poor. So our teacher salaries have stayed on track nationally. We're about the national average. Now, where we've cut is the number of teachers and other people and everything else that doesn't have an adult, right? The books, the buildings. So that's why we brought the school funding case to invest, inject more resources into the system. Bill Kosky is working on a Robust One case, which the CTA has intervened in. I brought the campaign for quality education case with some of our grassroots partners. And these are basically kind of joined at the hip now in the Court of Appeal. But if you have questions, I can go more into theory, but basically, yes, we're alleging that the fundamental right to education is being deprived of students because the funding is so low in the state. We're not able to quality education. And secondly, we're arguing that the system of common schools is essentially broken down. Our Constitution says the state has the duty to keep up and support the system of common schools. And we can keep up and support. That includes maintaining financially and over time, and they're not doing it. And the system is, at a minimum, is what the state has said, whatever standards, kind of core standards. The state's adopted and said everyone needs to meet. We got this testament. Well, then that's what needs to be kept up and supported. We ought to be funding our system on a level that delivers that and providing those supports that are beneficial. And somewhat uniquely in our case, we have a claim that says we don't have an adequately developed teacher quality system. We're not developing teachers. We're not attracting and retaining them by not providing enough supports to the schools. Build these learning communities. We're not evaluating them in a way that's going to lead to better performance. We're not seeing outcomes as a result. So I think it's really the only school funding system, school funding case in 40-year history of school funding that has kind of injected a kind of claim in it. So, well, important to do this. But that, I think, is probably a good place to end.
All right, so this time, panel's open for questions. Adam?
Thank you all for being here. This is an incredible panel. I think Joey did a great job putting this together. I'm gonna assert an assumption, and then I'm gonna ask a question. And any and all of you feel free to push back on the assumption or answer the question or both. So here's the assumption. My assumption is that, based on my observations, public schools are going to struggle until wealthy people feel that they have a reason to send their kid, to choose to send their kids to those schools. And so my question is, how do you create an incentive for wealthy people to send their kids to public schools?
Well, I'll start. I thought I sort of answered that with my presentation in the sense, I think you're right in the sense that, you know, we are in a situation where the public schools are so severely under-resourced that, you know, it's a problem. And I think the answer lies in part of what we were discussing is that, again, is to make every public school a great school. I mean, if you're living in a good, I think most parents, not most, but certainly loads of parents, you know, want their students to be in diverse learning environments. They recognize that there's a lot to be gained from your student being exposed to students from other kinds of backgrounds, maybe different socioeconomic backgrounds, different racial backgrounds, and the like. And you know, would like to make that choice. I think a lot of parents would, you know, recognize that. And I think the answer has to lie in each public school having the kinds of, again, you know, adequate staffing levels, small class sizes, you know, rich curriculum, you know, again, across many, many subjects, you know, plenty of student activities. I mean, if your neighborhood public school had all of that and had wraparound services and fabulous after-school enrichment programs, I think wealthy parents would make that choice. I mean, I think many of them. I mean, I think, you know, many wealthy parents would be incentivized to make that choice if they felt like all of those necessary components, you know, existed at a public school. And parents, frankly, appreciate convenience too. So there's a lot to be said for like the neighborhood public school in terms of you know, parents making choices for their lives. Oh, go ahead.
I was absorbing your question. I don't know if I wanted to push back on the premise, but I'm not going to push back on the premise just for the sake of answering the question. I think what's interesting, and I don't know if you guys had the same impression in terms of listening to the various views up here, but one thing that I want to emphasize is that I don't think that the concepts that we're espousing at any point are mutually exclusive. In other words, if you take the concept about what it would take to better a school, would it be better if you had smaller class sizes? Absolutely. Would it be better if you had, you know, in terms of infrastructure that wasn't dilapidated, etc.? Should there be an end to poverty? Yes. Is racism a bad thing? I hope we can all agree on that. You know, across the board, in other words, there are a lot of societal ills, but, and again, this is going to sound somewhat a bit of a piece of advocacy, obviously, because of the perspective that I'm coming from. The point I want to make, though, is all of those things are true, and it would be great to eliminate all of those systemic and structural problems. But an indispensable component of that, I'm a person that has children, and I can tell you that in looking in any environment, if there was an institution where I felt that someone wasn't an effective teacher, and there wasn't any way to match that person's impact on the class with employment decisions about that person, I'm not having it. And I'll tell you the reason why. I mean, and again, let me just take off the advocacy hat for a minute. It's basically common sense and fairness. I got to go out in the workforce every day, and I have to work and be evaluated every day based on my productivity in terms of what I'm doing. My children are the most important thing in the world to me. I'm putting my children in an environment, and you could throw as much money as you want to. You could reduce the class size. You could put in laser scopes in the classroom. You could have visiting lecturers from Zurich come in and talk about all sorts of things. That would all be fantastic. But if at the end of the day, someone wasn't doing their job, which is contributing to student learning, and the school told me, we can't get this person out, we're going to try to settle them, we're going to try to transfer them someplace else. What I'm saying is, if you don't address that piece of it as well, not that it's a panacea, which is the first thing I said when I got up here, but if you don't have a vertically and horizontally integrated approach that takes into account all these things that we're saying, I still think you're not going to be able to incentivize people to do it. So at the same time that it's not singularly dispositive in terms of reforming the education system as a whole, try reforming the education system without it.
First off, it's 4:04. Is it okay if you guys stick around for?
I'm happy to do that.
Cool. All right. Next question. See if this Rob, go for it. All right, then. First year, just go for first year.
Okay. Just kind of, I really just say that whole point about retention being a big issue. And what do you think, obviously if it's dropped from what, 12 years of experience down to the notable amount of experience being 1 year or somewhere around there, something big, has changed over the past 12 to 15 years or so. What do you think has led to that current state of affairs, and what do you think you've done to ameliorate it?
Well, I mean, I threw out some possible causes, I don't know that there's any causes. I think, I do think don't y'all look behind and over-focus on test-based accountability and over-focus on context has made it a much less interesting job. And I hear that from teachers. Mary Joseph on the state board of ed several years ago when we pushed through the change in the curriculum that we had this kind of scripted common core, open core textbooks. This day we need to be on this page, we'll be teaching that standard, tomorrow we need to be on that, and they have the script. Then the test scores come in and okay, now we're going to, I don't think that's created the best kind of working environment. That's what the teachers do. I think there's a better way to do it. I think it's not to say that we ought not to have tests and accountability and standards and hold teachers to them. I just think we need to be a lot more multifaceted in how we measure what we're expecting of our teachers, like the corporate world does. There's no corporate business that I know that says, here's your test. I don't care what you did, what else, or how good an employee you are. You didn't score one off on the standardized metric. Got fired. So I think that has had a big impact. And then on top of that, we lay all these other things about support and pay. That's completely. Lastly, there is, I guess there's another strand at play of support for, less experience in the classroom and all sorts of policy reasons, and I think it's completely science.
So I guess my question relates to both retention and attracting people to the profession. One is the general kind of idea. So the second is wondering how much, especially with LIFO, might actually deter people from entering the profession. When you know, especially if you're interested in teaching in a large urban district, that you're almost guaranteed to be transferred or laid off in the first 2 or 3 years of your career, maybe multiple times. Whereas you could go into most other professions, and the only reason you would lose your job in the first 2 or 3 years would be that you hired for a reason, or at least your employer or teacher services are particularly welcome. But if you're just taking a radical perspective and you're looking at teaching in a large urban district, not just in California, but in any state with LIFO, it's a really good chance you're not going to be in the same school or in the same district for more than a year for the first few years of your career. And looking at that instability at the beginning, how that may affect whether people who have other career options, or maybe after that first layoff, that's when they leave. Whether almost a system that flips the current model, where at the beginning you actually have some security, you're going to be able to establish yourself for a couple of years before you're sort of kicked out maybe twice. How much sense that might make, and helping people get past that 1 year or 2 years that seems to be what a lot of people.
Well, if I may, you're not actually guaranteed to lose your job or be moved around in the first couple of years. Your question assumes something that we need to be challenging in the first place, which is why do layoffs occur in the first place? I mean, I think that's the real question here. I mean, the real source of the problem is, again, that we don't have the resources, so we're laying off educators and other support personnel. It's not just teachers, right? We're laying off all kinds of support personnel and classified folks who help a lot, even security and what have you. We shouldn't, and historically speaking, we didn't have significant layoffs in California until the recession. So just to get an historical arc on it, it was really since the recession hit in the last few years where we experienced this tremendous number of layoffs. I don't think LAUSD, for example, conducted a layoff, in the 20 years before the recession hit. So, and what I think we need to be focusing on is to ensure, again, that we have the resources in the system so that we're not laying folks off. We shouldn't be laying off educators. The number of students in the system is growing in California every year. The students are increasing. So we need to keep up with that, with the staffing. And if the resources are there, there won't be layoffs in the first place. So I don't know that, if you're a teacher, I think there are a lot of other reasons why that, if you're interested in teaching, I think there are a lot of other reasons that would be much more of a concern as to why the profession doesn't seem appealing. Although frankly, the budget cuts, the problem with budget cuts and just the risk at all that, again, budget cuts will mean that your job will be enormously difficult and that yes, perhaps even could get cut. That's a function of the lack of investment, that our society is making in the schools.
I'm going to take a crack at the answer to your question, and the answer is yes. It is counterintuitive and illogical to expect that you have something that would cause somebody who is entering into a profession to lose their job, completely divorced from their confidence. And obviously, that has an adverse impact on people's morale. The question suggests the answer itself. Anytime you take bright, motivated, talented people and you tell them that you talk about arbitrary, you could be terminated, has nothing to do with how good you are. Has nothing to do with your impact on these students. It's just the fact that you were the last person in the door. The concept of LIFO actually is an accounting term, and we talked about how people are not commodities. It's interesting that concept is actually used here. Do you know why LIFO is an accounting concept? It's based on the notion of fungibility. Okay? And when you treat people in that way, and you use something irrational completely as a means to determine whether or not they're going to be employed, yeah. But I think the other thing is we can't count on legislative competence to make sure that the resources are there. I think one of the panelists up here said, if we can't have a sea change in terms of the externalities, don't we have to make the most out of what we have now? In other words, get maximum output out of the inputs that we have. Yeah, because if we operate on assumptions that things are going to work out or that they should work out, you're speaking normatively as opposed to descriptively in terms of the way things are. But there's one other current on this point, which is what's sad about this, and it kind of underscores the problem with the debate as I see it, is that it focuses so much on what's in the best interest of the adults. In addition, it doesn't talk about the harm to the students. And I think that's the issue, is actually having a dialogue where, as opposed to being so adult-focused, that it also talks about, for example, in the case of LIFO, what's the impact of LIFO on students in terms of having churn and volatility in your school and a disproportionate turnout in terms of teachers exiting, in addition to demoralizing teachers. So I think the answer to your question is yes, and I also think that if you look at it in the context of what education should be focused on, which is impact on students, it has that adverse impact as well.
I'd also offer a different perspective on your question and the first one, which is this necessarily a bad thing, or is it just a sign of the times? We have a different workforce growing up under different conditions, of different expectations about what they want to do with their lives. It may not be one thing only, but maybe many things. So something that we see with our hiring process is that people who want to go into education don't necessarily want to be a teacher for their whole life. They want to have an opportunity to fairly quickly move into administration or school leadership. So the financial components, such as having retirement go into something that isn't portable, like STIRS, as opposed to something that is portable but less secure, like 401k or 403b. Those are important, and we see it sort of increasingly in the people that we interview. So again, you sort of accept that for the way things are, not the way things should be. But how can you make the best of it? And that would be to be able to train teachers to be effective very quickly by building a very robust school model that may not give much discretion to a teacher, but achieves educational goals, and then gives those people an opportunity to move into school leadership relatively soon, so that they're willing to take that leap in the first place.
So I don't have a problem with seniority being a reason for retaining people and being get past your probationary period, and I think, 18 months, 2 years, as a district board member, that sure as hell ought to be enough to figure out whether or not this person is harmful to kids in the class. So I'm not going to give those people priority over someone else. But even young, if we have effective evaluation systems, which I don't think we do have, I think that's the other sort of bargain that needs to be there if seniority is going to matter, is that the people who are left are ones that are regularly judged to be effective in doing a good job. If you've got that in place, then I think we should be valuing seniority, not, even if, someone who's younger, they're, in fact, maybe it was slightly more effective than this 15-year. It's like, well, that person might be gone in a year. They haven't shown me that they're really committed to being. And so, I would say I don't have a problem with seniority, but I think we shouldn't be doing it if we don't have, not making sure that permanent people are supported.
I should clarify that it's not an either-or proposition. Just like I said at the outset, you could actually have seniority as part of a factor, but also have effectiveness. That may also assuage concerns that you're going to lose your job just because of seniority.
So, and I would add to your point about, I think that you were saying that, what about making it actually harder to get rid of early protect incoming teachers? In my mind, working in the district, there's always the thought of, well, what are the unintended consequences of a new law? And I see where you're trying to protect teachers so they get that time to grow. And I know from a teacher that took me 2 or 3 years to get to that point where I felt like, okay, I'm confident enough to sustain a classroom. But I can definitely tell you there are also cases where there are people just straight up that aren't a good fit. And I would, as a district attorney for a school district, would be scared of those. What would those protections mean for situations where we have them every year? We have teachers, people who come in. We really appreciate them coming in, but it just doesn't work. And I would be careful about wanting to imposing a new law that ends up in some way tripping up districts in that.
Got enough time for another question? You want to take a last? Go for it.
So I think I'll confess, my parents are both teachers in how I actually so I sort of see things from both perspectives. And I feel that one of the problems really is that there is no effective system, I feel, in place to evaluate teachers. And some people say yes, because you understand CTs. But as a student, I feel that if a law school had just looked at my LSAT score and made an admit or deny decision, I might not actually be in Stanford at this moment. And I don't think one test can show who I am as a complete person. So I sort of wonder if using one test to show how a teacher is as a complete person and their styles. But I'm just wondering sort of what effective systems could be built to evaluate a teacher or to use to sort of as a way of using efficiency. I, even for my parents, think they'd be open to using a system of effectiveness as a way to judge a teacher if there was a system that they felt truly reflected their abilities and not something that the proxy that doesn't come.
Several states use multiple measures. That's one of the comments that I made at the outset, is that you're not talking about a prescription with respect to one dimension, which is saying how someone did on an English or math test. You can also have student surveys, you can have peer observation, you can have principal observation. In fact, in the Gates study, which is one of the studies that talks about value-added methodology, it specifically talks about, in addition to the strength of using value-added as a predictive value in terms of how someone's going to be able to impact value to students, that you can use multiple measures. So I think that, again, to go back to initial premises, the idea of one test, I don't think anybody on this panel said anything about one test. The outset was always couched as being able to use multiple different data points so that you can hopefully amalgamate all those tests to get a whole picture of what someone's value is. But a critical dimension to it, in my view, is being able to use the data in the form of standardized testing for a couple of reasons. One, studies have shown that you can isolate and you can actually count for differences in people, particularly when you're using it in conjunction conjunction with multiple data. But the other thing, isn't it common sense? We hold the students responsible for their test scores, but the teachers have nothing to do with it. Again, I'm not saying solely as a measure, but isn't it kind of ironic that whether or not somebody can graduate or be deemed to be proficient and go on to a next grade and have to pass the test, as if that person was in a vacuum and they perform by themselves? Again, not saying sole responsibility, but certainly have it as a factor in addition to other factors in the calculus.
Go ahead.
I was thinking about, funny you asked that question, I was thinking about this a couple of days ago, watching Diane Rabbit. She was on the Daily Show a couple of days ago. I was watching.
Sorry, I missed that.
And she was talking about her book. And she was talking about how internet are not, essentially saying that standardized tests, using standardized tests isn't an effective way of evaluating. And I was thinking about any sort of evaluation we have, you're always going to have sort of unintended consequences to it. About whether it's someone's teaching to the test or suddenly an emphasis on a certain aspect that isn't accurate or doesn't accurately depict what an effective teacher is. And I was thinking, whatever that result is, whether it's one test or multiple tests, I think there's something very valuable in having it be somewhat democratically established. It's kind of like voting for someone. No one's ever going to be completely satisfied with who you vote, but the fact that everyone feels that they have voted somehow at least allows people to accept that and then continue to treat it. Right? And my takeaway from the evaluations or debate is that whatever it is something that we best I think is something that everyone can work on. So in the district, for example, we're actually working on with our teachers to create a new evaluation system that, and it's in the pilot program right now. We're actually working towards that.
I would agree with that. And, we supported a bill 2 years ago that would have done that. Change California's evaluation system to one that has multiple measures. It has to be worked out locally with the local union and the local community. And I think the biggest problem is not, at least, those bottom, the worst 2 or 3% or whatever it is. We know who they are. The principal knows who that teacher is. The other teachers know who that teacher is. It's sort of requiring a system to establish to formally identify that teacher and counsel and support them and move them out. So I don't think it matters that what the system is. We have a system. And I do know that I think it is harmful to make that single standardized test too big. And that there's a tendency among some people to really want to do 30%. It's distracting, it's too big a number, it's too unreliable, end sizes are too small, it discourages teachers from wanting to teach special ed and English learning kids. There's lots of problems with it. So I think that is the way to go. To have multiple measure system is sensible, kind of agreed to, but the real consequences of it is, okay, now we have to do something with that. As I said earlier, it's not really identifying 100%. It's like figuring out, all right, what about the 60% we're in the medical area that, what do they need to work on and how do we communicate that and how do we support that? I think that's what our evaluation system should.
I like to think of a test. It's a volume test, which is a component of evaluation. Call it, a quantitative, more objective than alternative evaluation schemes, efficient measure. Not perfect, and California just got rid of CST testing for this year, and everyone hopes the next round, new tests, smarter balance assessment will be better. It's going to count less towards the school's API score, which is a tacit admission on the legislature's part of what they thought of the CST. But I think also important to how you use a test, or about the merits of students you get, and they're tested 6 times a year, and your compensation-based portion of your performance-based compensation portion of your paycheck is based only on it, which we think is fair, and teachers have not complained about in all of the opportunities they had to have feedback into the process, because it doesn't disincentivize you going into a class that you know is going to be potentially more difficult or less difficult than anything else.
Can you elaborate on what you mean by that?
So there's a benchmark test assessment given in August, and then there are 5 more given throughout the year, and so the differential from that point of the year back to the benchmark, that's what
Anyone have any more questions? Okay,
Well,
let's make it quick.
So suppose you end up winning this lawsuit and the California Supreme Court, ends up declaring these laws unconstitutional. Then, now you expect to be torn something down.
It would be the trial court.
The trial court. Okay, the trial court. I'm assuming you might.
Wait, okay, go ahead.
Okay, so what happens then? Ultimately, you torn something down, but then there needs to be some kind of political process to build something back up to replace it. And how do you ensure that that there's actually any kind of productive change that comes out of that as a result of this? As opposed to, for example, I'm from Cleveland, and we had something similar with state education funding in Ohio, where it went to the Ohio Supreme Court, and the state funding was declared unconstitutional. Ultimately, nothing changed because the political organs on the other side just couldn't get their act together and actually make a substantive change. How do you know? What are you going to try and show that something like that isn't going to happen?
Let me give you 3 quick answers. First thing I know is if we do absolutely nothing, it doesn't change at all and it doesn't improve. That's a non-starter. I think we would agree with that. Is to sit here and say, oh man, it's too complex, it's too heavy, we don't know what's going to happen. We're afraid of what's going to happen in the future. That's not an answer. Okay. The second thing is this. The relief that I said that we wanted included a prescription that not only would there be an injunction against the enforcement of those statutes, but you can't put anything that's basically tantamount to those statutes that have the same numerical effects in their place. So basically what you're asking me is, how do I know that the California legislature, the state we're talking about, the legislator, is going to obey the law and comply with the Constitution? That's a good question. It's not the first time in the world that people in the legislature, we can think about Boundary Board of Education, we can think about all sorts of embarrassments in our nation's history, where our legislatures actually promoted the antithesis of constitutional protection. But I'm going to go out on a limb and make this assumption that if a court declares that these provisions violate the Equal Protection Clause of the California Constitution, I don't think it's a negotiable issue of what's going to happen in its place. What do I expect would happen in its place? That they're going to obey the injunction of the court and actually do something that comports with equal protection. That's really the answer. If you take the logical extension of what you're saying, it's, well, if you get rid of these, could it be worse? Well, that assumes that people won't obey the law. Well, couldn't they just come in and do the exact same thing? Again, that assumes that they're not obeying the law. Let me give you another example. You ever heard of a case called Doe v. Daisy? It's a case that was litigated down in Los Angeles. There's actually something called the STAL Act that requires that you actually have student achievement and performance be part of the teacher's evaluation. People had to sue in order to get that actually done and put into effect. But you can imagine, it was already on the books as the law. There was so much pushback on doing this, there had to be a lawsuit. What did the court do and what is the court still doing? Giving the parties time, that is the unions, that is the district, to work out a mechanism to be able to have evaluations that comply with that law, so that you can have time to do that. I'm taking your question both on the legislative level, I'm assuming that they're going to uphold their oath of office and obey the Constitution, and with respect to people at the local level, that you can have time to actually work to affect something that also complies with the Constitution.
Well, except the Constitution doesn't prescribe teacher employment protections. So it's not like, that's with all due respect, it's a fairly vague response. The reality is that these are legislative determinations, right? There's a lot of policies, employment protections, and other kinds of policies in our education code, and frankly in other statutes as well, that talk about employment protections. The Constitution doesn't tell us what those employment protections are supposed to look like. The legislature has to balance a lot of different interests and values and make determinations. Again, the legislature, as I mentioned earlier, does this all the time and has, in fact, revised these various statutes over time and many others. And there was just, Marcel's earlier reference AB 375, which was a bill that actually reached the governor's desk that would have amended the dismissal statutes to streamline them. And the governor vetoed it, saying that it was imperfect. It was a good try, but not perfect. He wanted it to go a little farther. But it was a step, and CTA actually supported that bill. Even though it would have dramatically limited discovery, the civil discovery that was described, it would have dramatically limited that, put a tight deadline on when the hearing process has to be completed, and it would have limited the number of depositions that a school district could take in a dismissal case to 5. And guess what? The California School Boards Association said 5 depositions was not enough. We need more. This is just part of the reality. So, you know, the legislative process is the place to have these conversations, but it's not clear what, if you just eliminated these particular statutes, what the legislature would decide to put into place. I mean, the Constitution specifically spells that out. So the legislature will have to, you know, that's something the legislature deals with all the time and would have to deal with here too, I think.
You can read Governor Brown's veto message. He didn't say good try. And I'm going to let the governor speak for himself in terms of what his perception was of AB 375. But our point was that it's actually made things worse.
Yeah.
And with respect to this issue also about, you know, what the legislative process, you know, my point is, again, we're going to have the assumption that the legislature is actually going to do something, but for the first time, as opposed to having a monologue in terms of teachers' rights, here's a concept. You're actually going to do things that are in the best interest of the students as well. That balance, with respect to all the decisional law on the books, is not good.
To be very quickly, I think maybe not very lawyerly, I think the answer to your question is it depends. And I think and I think it actually depends on what the judge said, like how far does he go? Say you scrap everything and say, I'm going to build it, or he throws it back to the legislator. The legislative process is, you know, a lot of different things can happen. The bill that both sides are talking about, you know, that came out of a very controversial case, and yeah, frankly, I think it would have made it much harder for dismissal. So the question is how the parties can then agree on whatever the outcome. It'll all depend on what the judge actually says.
All right, guys, let's give him a hand round.